Madam, Madam, good morning, court officer. Good morning, court officer. Idya sitting go.
Sitting ಇದೆ. Sitting ಇದೆ ಮೇಡಮ್.
Admission in the agreement, sir. ನೀವು ಓದಿ ನಾವು ಎಲ್ಲ ಓದಿದ್ರು ಅಷ್ಟೇ. Points out to the lacuna.
Court officer, madam sitting ಇದೆ ಅಲ್ಲ? Court audible ಇಲ್ಲ.
ಹೆಂಗಿದೆ ಹಂಗೆ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡಿ.
ಮೇಡಮ್ ಇದೆ, ಸಿಟ್ಟಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಕೇಳಿಸ್ಕೊತಾ ಇಲ್ಲ.
Okay. Thank you. ಇಲ್ಲಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಮೇಡಮ್, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳಿದೆ. Thank you so much. Thank you.
Okay. Okay.
ഒന്നും കേൾക്കാൻ വേണം.
Next week.
With your ladyship's most gracious permission, this is Advocate Nirubala here online. And the issue of ladyship, the protection which I seek under the MSMED Act, and the concept, ladyship may hear me patiently. There is a concept called termination. The doctrine of res judicata can apply only when there is a termination of lease. And my lord, in the surface proceedings, termination lease comes to an end when the entire recovery action is complete. So the difficulty is most lawyers and judges fail to understand that this is a problem when you create a tribunal in substitution of the civil court, which is, from a jurisprudential point of view, it is impossible.
Mr. Namra, the problem with you is you tell the law before the facts. The court has to understand the fact. What is the urgency?
Yes, the urgency is, I'll say it in 2 words. The urgency is my property is ought to be auctioned. And if it is allowed to happen, then it will lead to a concept called the Vinculant jurisdiction.
Your property to auction.
No, let me complete it. Ladyship, let me No, ladyship, let me complete 2 sentences, then I will listen to your ladyship.
Yes.
Then I am duty bound to answer all questions. The
Yes.
all problem is if the concept of pendente lite nihil innovator, that is to say, pending the termination of the list, the vinculum juris, that is, respective rights and obligations has to be maintained, shall not be allowed to be disturbed. And the entire scheme of the Surface Act or etc. is contrary to the basic jurisprudence. So there is the concept of res judicata is disturbed. So therefore, your ladyship, when your ladyship declines me the plea for the plea for injunction restraining the auctioning the property, the scenario here is your ladyship is order is literally cutting at the root of the concept of res judicata at its root. So because of the ignorance of lawyers and judges, this has happened. The lawmaker, those who enacted those who drafted the Surface Act, never knew that it is impossible to create a tribunal in substitution of civil court without cutting at the root the concept of res judicata. So the concept of so there has to be finality, means res judicata. There can be a res judicata only if there is a termination of lease. So thus we are unfortunately we live in an era where lawyers and judges do not know the basic jurisprudence. There is no res judicata unless termination of lease. If you allow a property to be sold, then the third party interest. Listen. Listen.
That judges are not understanding the jurisprudence.
I am saying. One second. I am a critic. I have to speak. If I don't speak, there is nobody else to speak. There is
Yes.
nobody else in the bar to speak. I have to speak. Then 1 second. Therefore, I am only asking your ladyship to not come in.
Call the list.
No,
2728, page
No, no.
number 9.
now 1 second. Let me, I am asking one question. Pass an order rejecting my plea of listing. Either allow it or reject it.
Yes.
No,
Page number 37.
no. Let me we have some courtesy. Let me say one word and let me leave the virtual courtroom.
Lordship, serial number 37.
37. Yes.
I've informed the other side, Your Lordship. Certain documents I had to produce.
You're for the
Therefore,
respondent.
I'm for the appellant. I've informed the respondent, Your Lordship. I've informed her.
At the request of learned counsel for the petitioner, this is matter after vacation.
Kindly fix
It
it.
is stated that already the same is informed to the counsel appearing for the respondent.
Yes. Your Lordship, a date may be given.
11,
Date
number
may be.
39 to 50.
January, we will not give the dates, like, we will not fix the next roster, the board of the next judge. Yes.
Page number 11, serial number 39 to 50. Page number 12, serial number 51 to 59.
Say number
55.
51, my lord, appearing for the first respondent in this case. Rest for 2 weeks time. I will intimate to other side.
Have you informed Mr. Dabali?
Already informed. In connected
At the
matter, I have
request
filed-
of learned counsel for the respondent after vacation?
in connected matter, I will file the dispensation memo.
Not all that we can't do it at this time. If you want to wait, please wait till the matter is called. You want to wait or shall I adjourn it?
2 weeks time.
Yes, after vacation.
Okay.
Page number 13, serial number 56 to 60. Page number 17, serial number 61 to 67.
Serial number 61, my lord.
60?
61. We are for the petitioner.
Somebody has moved the memo.
Yes, my lord. But due to some unavoidable situations, we are not able to argue today. We'll just inform the opposite party. Kindly grant us date on 10th, my lord.
After vacation.
My lords,
My lord's 10th.
There
because
can't be any
15th
short date. There are so many matters that have to be.
15th, we have matter in the trial court, my lord. That's why. Kindly
Do
grant
you
us.
argue today or it will come next after vacation? Repeatedly, matters can't be adjourned.
my
Yes.
lords, serial number 65, my lords.
60?
65, my lords. I appear for the petitioner. There's some inconvenience today, my lords. The certain documents have to be given by the petitioner
Same applies to you, either now, either today or after vacation.
after vacation, my lords.
Have you informed the?
I have informed the other
No further
side.
adjournments.
I
Why you
understand, my
want
lords. In fact, I've already intimated.
to- Keep this matter. We'll hear it when the matter comes.
Serial number 63,
Please,
my
my
lords.
Huh?
Serial number 63. I will
Yes.
inform the other side, my lord. Senior is not well. Kindly have it.
You are for the petitioner or the
For
respondent?
petitioner.
Yes, let's this matter after vacation. It
Obliged.
is submitted that the same is informed to the counsel for the respondent.
Obliged.
Yes, call the list.
My lords, kindly, my lord, one memo for posting. Sorry, my lord, I was making a mention at quarter number 12. Later I came to know. That is a GM DRT matter. But as against my lord, outstanding of rupees 2,75,000, yes, deposit of rupees 6 lakh my lord was made before the DRT. Sale notice was challenged. After deposit was made, my lord,
Is it a fresh matter?
fresh matter, my lord.
It will come, all the fresh matters
Especially
will
for
come.
230, my lord, because 7th, my lord, sale is fixed, my lord. My lord, I have deposited the amount.
Now,
Now the DRT has closed the
already they have issued the sale notice.
That was
In the light of the settled law,
That was not, my lord, I'll just make a minute. Lord, that was challenged before the DRT. DRT, my lord, directed me to deposit 6 lakhs. 6 lakh, my lord, I have deposited. Thereafter, my lord, DRT held, not that the auction notice has become infractious and the proceeding was closed. Now, again, on the basis of very same sale notice, my lord, they are trying to auction the property. My lord. I have deposited the money. I have all the proof, my lord. That is annexed.
tomorrow,
Just one memo for withdrawal of amount, death case, insurance.
yes, tomorrow.
One memo for hearing on stay application,
Huh?
MVC matter, hearing on stay.
Yes,
Kindly have it
listed
tomorrow.
basing on, yes, call the list.
List number 1.
Submission, my lord.
Serial number 1 for dismissal, party in person.
I think how many times we again will go back?
Serial number 59, my lord. Appear per respondent, my lord.
What do you want?
Pray for 1 week time. my
Have
lord.
you informed the petitioner counsel?
Gurudat, please,
Have you informed him?
please.
At the request of non-counsel, the respondent after vacation, it is submitted that the same is informed to the counsel for the petitioner. Yes, call the list.
Dismissal, serial number 1. Srija, V.
For the respondent
Party in
husband, my
person.
lords.
Ajay J. Nandan.
It's a case where, my lords, the
petitioner wife
Abhishek,
has not
One
sought
minute,
for
1 minute. In the corrected matter, you file your wakalat.
yes, my lords. On 20,
What is this writ petition about?
lords, the first petition, my lords, which is filed by the respondent wife. She is seeking, my lords, enhancement of amount and my lords, imposition of interest on arrears, and my lords, to attach the salary of the husband, and also to strike out the pleadings, my lords, and provide police protection to not to remove her from the property, my lords.
How many IAs were filed?
Or she is claiming, my lords, 9 lakh is due from the.
How many IAs were filed?
Yes, my lords, 6 IAs, my lords,
For all the 6 IAs, one writ petition.
one writ petition.
Hmm.
Moreover, my lord, the said miscellaneous.
Where is the order impugned? I mean, the order passed by the
I produced, my lords, in my writ petition, my lords, 501.
writ petition, first writ petition. It has gone to the Supreme Court also.
Yes, my lords. It has traveled, my lords, across 2 states and Supreme Court, and now, my lords, High Court, Karnataka, my lords. Lords, the first petition, my lords, the impugned order is not placed on record, my lords. In the second petition, my lords, have placed it on record.
What is the relief that she is seeking without filing the impugned order?
It only filed her IA, my lords, at.
No, let's see the prayer. Come to the prayer. Where is
Yes, my lords, page 96, my lords, may kindly be seen.
%12 interest on arrears rupees.
Lords, in fact, the miscellaneous petition, my lords, which was before the family court, has been dismissed for non-prosecution, my lords, on 18/8/2025.
18/8.
2025, my lords.
That is for?
The miscellaneous petition, my lords, which was filed, my lords, was transferred from the Supreme Court. My lords. There, my lords, she sought for enhancement of maintenance, my lords, and police protection. Lords, the said miscellaneous petition, my lords, is dismissed for non-prosecution, my lords, on 18/8/2025. As such, my lords, both the petitions have become
Does not assail any order of the
trial court, my lords. She does not assail any order, my lords. She just mentions, my lord, the judgment of Supreme Court, my lords, at page number.
Please come. The present writ petition is filed seeking the following prayers. Extract prayer at page number 96, paragraph number 74, A to F. When this matter came up on the last occasion, as there was no representation, the matter was directly listed today under the caption for dismissal. Today also, there is no representation. The writ petition is filed seeking a mandamus. The petitioner, the petitioner party in person, has not sought for any relief, has not assailed any order that is passed by the family court. In fact, the writ petition is in the nature of seeking execution of the orders that is passed by the Honorable Apex Court. The writ petition that is filed in this manner cannot be entertained, and this court cannot issue a writ of mandamus under 227 for executing the orders of the Honorable Apex Court, and the reliefs as prayed for by the petitioner are not maintainable. Accordingly, the writ petition is dismissed. What about the next petition?
Petition, my lords, the trial court, my lords, had enhanced the rent from 40,000 to 60,000 rupees, my lords. The same is challenged before this honorable court, my lords. The said Mrs. petition, my lords, is dismissed. As such, my lord, this petition would not serve.
That?
My lords,
What is enhanced?
the payment of maintenance amount to the wife, my lords.
Is enhanced from 40,000 to?
60,000 rupees, my lords.
Hmm.
I was earning, my lords, 1,04,000 rupees.
Hmm.
But my lord, 60,000 was directed to be paid, my lord. The same is challenged before this honorable court, my lords.
Hmm.
I've already paid us, my lords, the substantial amount, and also the my lords.
The main application itself is dismissed.
Yes, my lords.
The writ petition is filed.
Place on
Questioning
record the
order, huh?
copy of the order. my lords.
Questioning the order passed by the family court where the maintenance is enhanced from 40 to 60.
Yes, my lords.
40 to 60. Learned counsel for the petitioner submits that. Submits that by order dated 18/8/2025. The trial court had dismissed the miscellaneous 91 of 2015 for default, as there was no representation on behalf of the respondent herein. And the order dated 18/8/2025 reveals that she has remained absent for a long time, since 23/7/2016, and no submission is made on the petition for a long time. It appears that the petition is not interested, the respondent herein is not interested in proceeding with the petition. Hence, the petition is dismissed for default. It is submitted that as the miscellaneous itself is dismissed, nothing remains to be considered in this petition accordingly. In the light of the dismissal of miscellaneous 91 of 2015, this petition is also dismissed.
Grateful, my lords. No, there's a mistake, my spelling mistake, my lords, in the cause list. My lord, there's a spelling mistake, my lords, in my name. It should be HUDDAR, my lord. It's tappa.
Correct the name of the counsel for the respondent. It should be Abhishek or?
The HUDDAR.
It's Uddar, it's HU. No, it is, no, respondent is party in person. In 1.1, learned counsel submits that. And then it's permitted to file wakalat within 1 week.
I've already filed, my lords. 28/10/2024.
It's already filed, it is not reflecting.
Not reflecting.
Yes.
Cell number 2 for orders matter, Kalpana PV.
My lord, I appear for the appellant in this matter. My lord, I request for a reissue of the paper publication, my lord. My lord, I had taken the paper draft in time, my lord, but I could not give it for paper due to personal inconvenience, and there was the time had lapsed by then, my lord.
It's all waste of time. MFAs
Sorry,
of 2025. Again, where have you filed an application at least for that?
My
For
lord,
issuance of the notification.
my lord, they said the application is not necessary. That is why I did not file it, my lord.
Though this court has passed, give the order sheet.
Yes.
When is this order passed? It is on 17/9.
Yes, my lord. Before 17/11, I was supposed to.
Though by order dated 25/9/2025. This court has directed the petitioner to take out notice to the respondent, number 2, by way of substituted service, by publishing the same in Ganta Kannada daily newspaper, and to mention the date of hearing as 4/12/2025. Then counsel submits that due to oversight, the same could not be published, and hence seeks a direction to reissue the same. Accordingly, petition is permitted to take court so and so. Give the dates.
Draft on or before 11 and 18/12, hearing date on 7/10.
But no further time
Yes, ma'am.
Appel.
in all the appeals, two
all
to
the
point
three.
1 2. Yes,
All the-
3.
Yes, ma'am. Sale number 3, Girish Yasan,
Kindly 1 week, madam. Respondent number 3 already PF paid, madam. 12 September 2020.
Time default order.
sale number 4, Range Gowda,
1 week time I granted. Another connected matter. there, madam.
A week's time default order, list along with so and so.
Alam Basti.
Yes, 5 list after service of notice. 6,
Sale number 6,
Needful done.
it is submitted that the needful is done, list after service of notice.
sale number 7,
Case preparing for the appearance, madam. Only the result number 3 and 4. 3 is the mother of the deceased Srinivasan, the petition appellant to husband. She also died with accident at Chittoor district. Thereafter, Lakshmamma's mother, she also died during the COVID. The receipt already produced before this honorable court.
No. As on the day
Please.
when the judgment is pronounced,
Please,
they were alive.
they were arrived.
So you have to carry out the same cause title here and mention all that. That you are not, that's what you are not. Please come to the cause title of the, in the award. Let's see the award.
Please, madam. 3 and 4. 3 and 4 and 5. It is.
Where are all these?
At
Have to
the-
carry out as it is.
No, my one submission, madam.
Yes.
That is respondent number, the Lakshmamma petitioner who is in the lower court, number 1, she died during the COVID time.
That you have to
That has been
mention it in the cause list.
That I
If the
mentioned.
cause no, cause title should be as it is.
Please.
There should be a note below. That's what they're insisting.
I stated in my appeal also, page number 7.
Not that. The petition, office objections are sustained. Petitioner shall carry out the objections
sale number 8,
within 1 week. Yes.
Date may be given, ma'am.
yes,
1 week.
Date,
1 week.
date may be given
For what?
regarding the, today itself I am going to complain.
Once the office objections are complained, shall be complied within a week. List this matter once the office objections are complied with. Yes.
sale number 8, Raju
List
S,
after service of notice.
sale number 9,
A week's time, default order.
sale number 10,
For appellant in this case, Your Honor, respondent number 1 already served in a B Pradeep, my lord. The only notice to respondent number 2, my lord.
Non-compliance of office objections
Yes, my
raised
lord.
on process memo
Yes, my lord.
to furnishing of IA 1025 2 says to issue notice to R1 and R2.
Yes, my lord. Already served the copy of the B Pradeep, my lord. Respondent number 1.
Where is
insurance.
the order to serve on him?
No.
Then
Please, Your Honor, kindly 1 week time may be given.
a week's time to comply with the office objections.
sale number 11,
Your Lordship, the office objection is
pages,
that New India Insurance, it has been mentioned in the judgment instead of the tribunal, instead of New India Assurance, Your Lordship.
But what the problem
Your
is, that is your, you have to take care
True,
of
Your
it. Your counterpart has to do. Why should the court say that whatever is the name we will or the objection raised by the office is not
The
correct?
company has instructed all the trial court advocates also in this regard.
No,
Your
Nowadays,
Lordship.
this has become a, no, I mean,
yes,
a daily affair.
Yeah, they have taken it very seriously and have instructed all the trial court advocates in this regard.
No,
Your Lordship.
let them seek for a clarification in this also.
Pardon, Your Lordship. Because in the connected matter, this honorable court is kindly.
That's what
not
I'm
to
saying,
grant.
it is real, because the objection that is raised by the office is correct. Because it should match, the name should, if it is not, your counterpart should have taken it long back. But still the court is showing the indulgence. I will not show this indulgence anymore.
Yes, Your Lordship.
The office objections are overruled.
May I request for a stay, Lordship? The connected matter petition has been filed
What
after.
is this?
after
It's a
the-
case of death or injury.
Injury, Your Lordship.
How much is
Beyond the
amount?
limitation period, after the amendment of the MV Act, the claim petition has been filed beyond 6 months, Your Lordship.
It is submitted that the claim petition is filed beyond the period of limitation, and the court cannot entertain or not to have entertained the claim petition. Considering the submission, they shall be stay 50%. They shall be stay on the condition that the petitioner the appellant shall deposit 50% amount within 4 weeks. Notice to the
Before the
respondent,
tribunal, Your Lordship.
wherever you want.
Yes, Your Lordship.
sale number 12, Syed Abdul Sabur.
I'm
This
for
after
appellant.
service of notice.
Cell number 13. 13,
Yes.
maintainability. Lingraj.
I appear for the appellant. In this case, the claim petition was filed beyond the period of limitation. This I questioned before in WB proceedings. When WB proceedings are still pending, the MACT brushed aside my request and has passed the orders, my lord. So that the limitation issue is coming up before the Supreme Court on 8th. If that is decided in my favor, this will. If that is decided in my against me, then I have to withdraw this. And in the
Then
meantime,
we'll take it up after some time.
pardon,
We'll take it up after some time.
after vacation.
This is matter after vacation. Yes, next.
Cell number 14. Girish B. Baldare.
Give that letter. For respondent. This court had passed an order in MSA number 41 of 2022, dated 3/4/2025, directing the court to dispose of the LAC number 38 of 2023 within a period of 6 months. The learned judge was stating several reasons as sought for a week's time. There is a sought for another 4 weeks' time to dispose of the matter, considering the reasons stated. Another 4 weeks' time is granted for disposal of the same, and it is made clear that no further time will be granted. Yes.
Cell number 15.
Correspondence, same matter.
Same, and all that, date of order is one and the same in all this?
Yes, your lord. Same, your lord.
Same one, yes. 15,
16.
16, next 16.
P.
Only 14 and
Narayanappa.
15 same order.
15.
16,
16. Narayanappa.
this court on 7/8/2025 had directed the family court Kolar to dispose of the criminal miscellaneous within brackets FC number 57 of 2020 by 15/11/2025. Now a letter is addressed to the principal judge, family court Kolar, stating that the regular presiding officer of the court is transferred in terms of the order dated 30/10/2025, and the office has fallen vacant. As such, the petition could not be disposed of. The learned judge has requested for a 6 months' time to dispose of the matter. Considering the request, this court deems it appropriate to grant 3 months' time to dispose of the matter. And it is made very clear that no further time will be granted.
Cell
Yes,
number
ma'am.
17. Akshay Swami.
The RPFC is filed challenging the order of interim maintenance, my lord. The office has raised objections with regard to maintainability. I may be permitted to carry out amendment and convert it into a writ petition.
The office has, the RPFC is filed questioning an order passed on a IA where interim maintenance is granted. The office has raised the maintainability in view of section 19(4) of the Family Courts Act. Office objection with regard to the maintainability is sustained. The petitioner is at liberty to convert the same into a writ petition within 1 week
Please.
from today, but within 1 week from the date of receipt of the copy of the order. For the statistical purposes, the RPFC is disposed of.
Cell number
You
80,
oblige.
B. Mohan.
What is this? Writ petition may be disposed of as withdrawn with liberty to file fresh petition. No representation on behalf of the petitioner. List this matter for dismissal. Yes. Dismissal. Because he's seeking liberty. What liberty we don't know.
Cell number 19,
Respondent in this matter.
Kailash Kumar.
Non-compliance of office objections.
Lord, this matter-
Early hearing on statement of objections. Your objections, I
I'll
think.
just compare, my lord, what had happened in this matter, my lord. My surface measures, my lord, assailed before this honorable court, that is at page number 126. Earlier occasion, my lord, this honorable court granted certain interim order, subject to payment of some money, which they are not compliant, that is annexure R3 in my statement of objection. They filed one more writ petition before this, my lord, instead of complying the, my lord, the writ petition, my lord, earlier order.
No, he is not there. We'll post it for dismissal and say. This is matter on Tuesday for dismissal. Tuesday. Dismissal, no representation on behalf of the petitioner.
Cell number 20, MJ Alva.
You that?
For the petitioner, we have filed memo for withdrawal of the matter is settled before the mediation center of the family court. In MC petition.
The memo is filed seeking to withdraw the writ petition. It is stated that the writ petition is filed questioning an order that's passed and an order that is passed on IA under section 24 of the Hindu Marriage Act dated 22/8/2024. During the hearing on this petition, at the request of both the parties, the matter was referred to the mediation for settlement, and the matter is settled as settled, and the marriage is resolved. As per the terms of the mediation agreement dated 29/10/2025. And so present memo is filed. The memo is taken on record and the petition is dismissed as withdrawn in the light of the settlement between the parties.
21, Vaiti.
Memo for withdrawal.
I was permitted to convert the RPFC into WPFC. Since the file was not traceable, I filed a new petition, so I'm withdrawing this petition.
I'm not able to understand this.
The reason is, my lords, in CMIS, based on the IA, I had filed RPFC. RPFC was not maintainable. I had to file a WPFC. So I was permitted to convert the RPFC into WPFC. Since the file was not traceable, I could not convert it. So I had filed a fresh petition. So this petition I'm withdrawing.
No. Which is the fresh petition you have filed?
One more petition, my lords.
They already converted. This is WP 7817.
I have not converted my. This file was not traceable at that time, so I
Please
did.
read your, you say that you have filed an RPFC.
I had filed an RPFC that got converted into this WP 7817 of 2025.
Yes.
This file was not traceable for me to convert, my lords. Office objections are still there. So I filed a new writ petition.
You're saying that the petitioner has preferred a revision petition.
I had
That is
preferred
RPFC.
That was RPFC. That got converted.
21 is showing as WP.
Yes, my lords. That got converted. New number was given.
Hmm.
This
No, you're saying that the file is not traceable.
It was not traceable when I had to convert it, my lords. That is the reason.
That's not what he's saying. He says he has converted this. This is after conversion is this number.
This is the number. After conversion, this is the number. I've already filed one more petition. So this
How
time.
can you file?
My
When
lords?
there is an order, how can you file? No, when there is an order
Yes,
to
yes, my
convert
lords.
this.
Yes, my lords.
open another writ
I went to the registry. The file was not traceable, so there was some urgency. So I filed, my lords. That's why I filed a memo for withdrawal. Once
Memo is
that-
filed seeking to withdraw the writ petition. Memo is taken on record and the writ petition is dismissed or withdrawn. No, there is a procedure just like that. You can't take your own.
There was some urgency. That was the reason.
Have you stated all this in that writ petition?
Yes, my lords. Yes.
Yes.
Cell number 22, Samir Hassan.
Is there any interim order in this? No interim order. A memo is filed seeking to withdraw the writ petition. It is stated that the petition has become infructuous, dismissed as infructuous. The memo is taken on record. Yes,
Cell number
23.
23,
History after service of notice on the respondent.
cell number
Raise time to file wakalat, my lord. For respondent, I have.
So submits
Been
that.
served, my lords. It's been served, my lords. Petition copy has been.
It is submitted that so and so has instructions to file wakalat on behalf of the respondents. Any
It's any
objection?
date before vacation, my lords. It pertains to child custody, my lords. Any
Let's
date.
hear what is it.
Raise time to file wakalat, my lord.
You file, we'll see what it is. Give the file 23. Yes. Where is the impugned order?
That's in the 26, my lords.
20?
26 annexed A. We
You're
have
for the
filed for
father or the mother?
modification of the order, my lords.
No, you are for the father or the mother?
Mother, my lords.
We are the father of.
Okay, number 4 filed by the second petitioner is dismissed.
Yes, my lords, it's dismissed. For custody of child, my lords, for the modification of the settlement agreement, my lords, is not complied by the husband, my lords, is not letting mother to visit, my lords. Visit or contact the child.
Get instructions.
13B ನಲ್ಲಿ
Any date may be given before occasion, my
Yes,
lords.
get instructions. This is matter on 16th of December.
Obliged, my lords.
Yes, 24.
cell number 24,
Rashapam, kindly pass it over, my lord. Kindly pass it over, my lord.
It's coming up for non-compliance of office
Yes,
objections
my lord.
about the
I'll make
council
my
submission.
submission. Kindly pass it over, my lord. Kindly pass it over.
Yes, next.
cell number 25,
Obliged.
25, Meenakshi K, rectification of.
You appear?
I appear for respondent, one of the only respondent, with the copy we served on us.
So and so submits various instructions to file wakalat on behalf of the respondent. Land counsel for the petitioner shall serve the copy of the writ petition on the council. This is matter next week.
Your Honor, I have
Yes,
already
ma'am.
served the copies. I have already served the
Yes,
copies.
sir.
No, I have not been served.
My colleague has served.
But even the objection says that on the process memo that needs to be done.
So only. Yes, next.
Cell number 26,
Lord, I appear for the caveat. The
What
copy has
is
not been
this,
served.
The maintainability is the third party to the MC proceedings, my lord, has challenged the order because what is sought for, my lord, in the application filed by the petitioner before the trial court is, my lord, a wide sweeping. They have asked for CCTV footage, booking details of, my lord, anybody who's been in that resort. May I just take my lords to the application, my lords, kindly.
No, what is your submission to serial number 1?
My lord, there's a judgment of the coordinate bench, my lord, which says that even a third party can also challenge an order if he is not a party to those proceedings and it fixes the rates.
Copy needs to be
There's a
served on
judgment of
me.
the coordinate
I'm
bench.
I'm in caveat.
He says he's on caveat and papers
Please.
are not, sir.
My lord, the caveat was not put up for us either
But
way.
sir-
I'll ensure that is done.
The copy shows Arun.
That I'll
Governor
ensure,
as
my
on
lord.
caveat.
That I'll ensure it's served. The only urgency here is, my lord, I
Not hearing
do
it, we
understand.
can't hear any urgency.
Then-
Let counsel for the caveat has submitted the papers are not served. Counsel for the petitions has served the copies on the caveator. List is matter.
Tomorrow, my lord.
Counsel for the caveator. Yes, Mr. Gondraj, tomorrow?
Monday, may I request, not Monday.
Monday.
Just
Monday.
one submission which I have. The caveat is not as against me, my lord. That's not as against me. The caveat is filed as against the respondent there.
Give him the papers.
I'll do
Monday.
that, my lord. Please.
Manjula.
I have filed this IA for recalling the order date of him.
What is the order dated 22/8?
MFA number 70% of disposed of, please.
Why
My
should
appeal
we
is also
record?
pending, please.
Hmm?
In when my appeal was filed much earlier to the claimant's appeal, please.
Hmm.
Served on by WhatsApp Kalsi this one already. Now he filed the execution petition also, please, on the basis of.
No, you were represented on that day.
On that day represented.
Then-
I have submitted also. My appeal is also not put up on that day. Appeal will be on negligence.
Counsel, I have recorded the contention.
Definitely, please. Ma'am.
Then in that contentions, it is nowhere recorded that another appeal is pending.
Pending, well, ಅವತ್ತು ನಂಗೆ ಹೇಳಿದ after disposal of the MFA, I have wrote the company to satisfy thereafter they told me that company appeal is all pending filed by me, please. That's kindly took up together and
What I will do is, now I will recall this order on costs.
please, ma'am.
Because your insurance company, what are they doing?
On that day, my appeal is not put up on that day, please, ma'am.
You should tell the court that your appeal is there. Otherwise, how will the court know?
ಅವತ್ತು ಲಿಸ್ಟ್ ಗೊತ್ತಿರ್ಲಿಲ್ಲ. I do not on that day. That's why thereafter, after disposal, I came to know that.
Now, this
That's
is
a
now
humble
another
request.
round of litigation now.
No, I'm
enough
ready for
time,
disposal of the matter also,
Pass
Lord.
orders.
It may be taken up together and disposed of the matter. That's my humble request, sir. That's only. Please, sir. They have filed the execution petition also. That's my humbly requesting. Took up together tomorrow also. I'm ready to today also, ma'am.
No, court should have time to take it up. We will see.
Please, ma'am.
This is smarter after vacation.
Lord, the execution is there, ma'am. One
I
sub-
will not, please. I will not consider these kind of.
Lord,
requests.
company appeal without a disposal. When
That is your problem. The IA is filed seeking to recall the order dated, the order passed by the judgment that is passed by this court. It
I
is
wa-
stated that there is a company appeal, company appeal and
MFA
it was not,
1094 of 23.
it was not listed on the day. Land counsel for the insurance company was heard on that day and it was not brought to the notice of the court that an appeal is pending that is filed by the insurance company. In these circumstances, at this point of time, this court do not find any reasons to go into that aspect. This is matter after vacation.
Cell number 28.
I'm ready for disposal also today.
I have no time for the disposal now.
Tomorrow, day after
No
tomorrow.
doubt. There are so many matters. Yes.
28.
Notice to the respondent.
Cell number 29.
If I apply, madam.
I am for the respondent. What is the notional income to be enhanced? Accident is of the year
I number,
2017.
no, I'm not hearing any appeal now. I number 1024 to condone the delay of 340 days in filing the appeal. For the reasons stated. In
Only
the accompanying
enhancement of
affidavit, the delay is condoned on the condition that they are not entitled for the interest for the said period. Admit, post for final hearing, call for the TCR.
Cell number 30.
One
Lok
submission
Adalat
in my-
will be posted for Lok Adalat.
I'll refer this matter at the request of both the parties to the Lok Adalat. Next 30.
One submission please, in my case. Kindly impose cost on me, please, ma'am, and can recall the please.
I will not hear it now. That's the point I'm.
Kindly fix the date even after vacation also, please, ma'am.
It
Humble
will
request.
come after vacation. Yes, 30.
Cell number 30.
Kindly fix the date, please, ma'am.
Lord, I am for the respondent. Post this matter
I
along
number
with
1024 to
MFA
condone the delay of
4156
53
for
days.
24.
Condone, huh?
Post this matter along with MFA.
List along with so and so.
MFA
Admit final hearing
4156
PCR.
for 24.
Yes, next.
Cell number 31.
Applied in this case, my lordship.
From
This honorable court has issued notice on 17/7, my lordship. I have taken steps on 21st July only, my lordship. The officers note that I have not taken steps. On the basis this dismiss again respond number 2, my lordship. I filed an IM and recall the order and permit me to take steps, my lordship. Already taken steps, my lordship, in time. But the office note that
23/9/2025 order shows no representation on appellant side on call. Also, as per the office endorsement, appellant did not choose to furnish requisites for sending notice to respondent number 2. Therefore, appeal against respondent number 2 stands
on
dismissed.
July only I have taken steps, my lordship. 2 months back only I have taken steps, but the office has not put up, my lordship. But my process. When the notice is issued on 17th, I have taken steps on 21st.
A coordinate bench of this court on 23/9/2025 has dismissed the appeal against respondent number 2 as the petitioner has not chosen to furnish requisites for sending notice to respondent number 2. And there was no representation on behalf of the appellant. Land counsel appearing for the appellant submits that in fact he has furnished the requisites in the month of July.
July 21st, my lordship.
July 21st, and as the same is not reflected in the, is not reflected in the office note. And as such, this order is passed. Considering the submission of the council and the fact that he has already furnished the requisites, the order dated 23/9/2025, dismissing the appeal against respondent number 2 is recalled. This is matter after service of notice. Yes, next 32.
Cell number 32.
May be permitted to withdraw 50% now.
Yes.
Cell number 32. 32.
Okay, number 2 of 25 for withdrawal of the amount. Yes. Yes, Mr. Vijay Kumar.
May be permitted to withdraw 50.
Yes, I number 1 or 2 of 25 is filed seeking to withdraw the amount. And counsel for the appellant submits that there is no objection. Accordingly, I number 2 of 25 is allowed, permitting the petitioner, permitting the respondent to withdraw the amount. 33.
Cell number 33.
I number 2 of 25, 189 days for the reasons so and so.
Refer to local adult. Refer to local adult.
Request of both the parties to refer this matter to the local adult. 34.
Cell number
Please.
34.
Notice to the respondents.
Cell number 35.
Yes. Yes, 35.
Notice has to be.
Notice to the respondent.
Stay up to 50. Cell number 36.
Yes, 36.
In this case, I am the respondent, my lord. After getting interim order, madam, they are not deposited the conditional
Amount.
my
No
lord.
representation. List this matter for dismissal next week. Give a date next week. Yes, 38.
8th, ma'am.
11. Cell number 37. Agenda. Cell number 38.
Your Worship, this is matter.
Atab Singh.
Yes, Your Worship, this matter be the 4 rates listed and is for final arguments, Your Worship. So we are ready to argue right now. We have all the judgments. I will not take more than 10-15 minutes, Your Worship.
There is a counsel for the petition.
Your
Other
Worship,
side.
even that last time she never appeared, Your Worship. Well, Your Worship has interacted with the parties in the chambers, has also spoken to the son in the chambers.
But nothing, nowhere it is reflected that she is not there. None of the orders reflect that. No representation earlier.
But even on the previous date, they never appeared.
For
Your Worship.
27/11, only, even that is not recorded by the court.
But Your Worship, the fact of the matter is that today the matter has been listed after a long time and we want to argue the case. Now she
Other
is,
side should be there, but how can I remember, how
But
can you
the
hear
name-
it on a piecemeal basis?
Your Worship, my arguments can be taken if they wish to. The fact of the matter is,
No representation on behalf of the respondent. Land counsel for the petitioner submits that even on the last occasion also, there is no representation. The matter is posted for hearing it finally listed on 11th December. Yes.
Cell number preliminary hearing. Cell number 39.
even one of the items is some office objection, which is a minor one. We'll clear it, allow us to clear the office objection in one.
38.3, the office objection shall be complied with by the time. next
Can
day.
it be on the 12th if possible, Your Worship? Can it be on the 12th if possible, Friday?
Friday might not be possible, 11th.
Then we'll have it whenever Your Worship please. 11th.
Yes, next.
Cell number 39. Tyagarajan.
Petitions in it.
Petitioner husband has filed the custody of the child, your lord.
Hmm.
Yeah. For interim custody, sorry, interim so visitation rights, he has filed the application, your lordship. Like even the, every Saturday we seek for the permit, file the application to visit the child for every Saturday, your lordship. Third Saturday, 2 hours has been given, your lordship. That is the impugned order.
Take out note of hand summons.
Please, your
Then counsel for the petition is permitted to take out hand summons on the counsel appearing for the respondent. Once the memo is filed, list this matter.
Cell number 40,
trial court counsel,
Huh?
the trial court counsel will take this.
Counsel only.
cell number 40, Vinay Kirti.
Appear for the petitioners.
Hmm.
Husband petition, your lordship. So maintenance of the 10,000 is granted.
How
Now
much?
the wife is, your
How
lordship,
much is granted?
10,000 rupees to your lordship.
What is your income?
I am the running a, your lordship, as a working as a teacher in the tutorial for providing a coach.
According to you, what is your income?
My 30 to 40,000.
Hmm.
Now she is working at North Trust Company. She is MCOM graduate. She is earned 1,20,000 rupees.
Is it part of the record?
That is in the assets and liability, we are clearly stated that. Your
Well,
lordship.
no, it is not about you stating.
Yes.
As she stated,
Yeah, she is not stated, but your lordship subsequently also she issued the notice that to claiming the right over the property of my father, where also she stated that I am earning 1,50,000 rupees salary. You are taken the entire salary for the purpose of the
Where is
household.
that?
That is the notice. Now she issued that, your lordship, after granting the interim order. Your lordship, in
have
para
you filed
3.
along with this? Have you filed?
No, your lordship, after filing of the petition only we are received this notice.
Where do you get that?
The para 3, your lordship. My client
During
was.
the year 2017, that is at the time of marriage, my client was
No,
working
the
at a
subsequent-
company, earning a salary of 1 lakh per month.
Now also,
No, she never said so, that she is earning as of now.
because only she left 2,000 at the time of filing the MC.
Not going to all that. Please tell the court. As far as this, notice is concerned, it only refers to her salary as on the date of marriage. She never said as on today she's earning.
Because your lordship, she now, based on that next.
No, you have
based on that
40,000, you have 40,000, she is granted 10,000, nothing to interfere, let her come, we will see. Notice to the respondent.
Cell number 41,
Petition is permitted to take out hand summons to the respondent and shall file a memo to that effect. Once the memo is filed, this is the matter.
Your lordship, I'll serve the counsel to that.
Counsel only, hand summons to the counsel.
41,
For the
Devaraja M.
petitioner, my lord. And the petition is
40?
the
Yes.
petitioner is the husband, my lord.
Hmm.
He's challenging the interim maintenance passed by the learned family.
How much?
5,000 rupees. My lord, the reason is he is unemployed and he is disabled, my lord, disabled of 40%. Even she is unemployed. He is living on he is dependent on his parents,
Did she say so that she is employed?
unemployed in her assets and liabilities. She claims
Employed or unemployed?
unemployed.
We will
She
see.
claims.
We will see.
Lord, at least the arrears may be stayed, my lord, payment of arrears.
How much the arrears will come to?
My lord, she has filed this application in 2020. And she has led the evidence only in the year
Some
2024.
amount you need to pay. We will not grant a blanket.
So, Lord, at least from the date of order, I may be permitted to pay, my lord.
No,
The
that
previous-
anyway you have to pay, that 5,000 you will continue to pay.
Please.
Arrears, some amount you need to pay.
From, my lord, this order was passed in February 2025. From that day, I may be permitted to pay, my lord. The previous ones may be stayed.
Please come, then counsel for the petition submits that. The court has granted an amount of rupees 5,000 as maintenance. The petitioner is unemployed and also is
Disabled.
physically handicapped. And as per the disability certificate,
Please.
it is 40% disability. It is submitted that the court, without considering all these aspects, has granted maintenance. Considering the submission of the land counsel to the petitioner, they shall bestow of all further proceedings on the condition that he shall continue to pay 5,000 per month. However, as far as the arrears are concerned, he shall pay from February 2025. The arrears from February 2025 till today shall be paid within a period of 8 weeks from today.
Grateful.
The same hand summons in this also.
Grateful.
Yes, 42.
Cell number 42,
If you're for the
Kaveri
petitioner
Timaya.
wife, my lord, I filed a petition for divorce. The current application, my lord, is for school fees for the child. Common orders have been passed on the wife's application for maintenance, which I had sought for a sum of rupees 10,000 that came to be rejected. I have filed a writ petition challenging that. And then I had filed an application seeking for a sum of rupees 20,000 for the child's maintenance. That has been allowed in part, rupees 10,000 has been granted. I have filed a writ petition seeking for enhancement. And the present writ petition, my lord, is for the school fees of the child. While the order says it has been allowed in part, it does not specify the amount. I request for the other two writ petitions also to be tagged along with this writ petition.
Already in that, respondent is served.
No, they have not, it's not come up before this honorable court.
The petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect. List along, once the memo is filed, list along with, list this matter along with the other two writ petitions. Yes, next. 43.
43.
I am for the petition, my lords. I am for the petition, my lords.
Yes.
Lord, this petition, my lord.
Yes.
The order passed on IA number 1 and 2, my lord. Sorry, 3 and 4 and 5. Lord, in this matter, my lord, I filed a petition under section 13(1)(1)A and B for dissolution of the marriage.
Where is the order? Where is the order?
Order page number 19, my lord.
It is an order passed on IA number 5.
IA number 5, my lord. This is regarding permanent alimony. But the main petition came to be allowed for dissolution of the marriage. That petition came to be allowed. But I sought for permanent alimony, my lord. That application came to be rejected.
What is the respondent?
Cell number 44.
Yes.
Appaya.
Appear for the
PP.
petitioner, my lord. April 2025, we have paid in one shot the entire OTS amount to the second respondent. Till today, they are not giving us the no due certificate and the no objection certificate to release the charge on the assets.
Which is the bank?
IFCI, second respondent, IFCI is a Government of India institution. Used to be called Industrial Finance Corporation of India.
Who represents Union of India?
Union of India has been served, the ASG has been served, my lord, in advance.
I represent respondent number 1, my lord, BM Kushalappa. Only respondent number 1, my lord.
My CIBIL score is getting affected.
No, you're seeking, your relief is against respondent number 2.
Respondent number 2.
Where is the ASG?
The respondent number 2 has separate the panel councils, my lord.
No, it says ASD served.
ASD for respondent number 1, my lord. I am appearing for respondent number 1.
Which
respondent? Who is?
Which respondent?
BM Kushalappa, my lord.
You appear for the second respondent.
No, my lord, respondent number 1 only, my lord.
BM
nomination is, yes, my lord.
Mr. GM Kushalappa, BM Kushalappa for respondent number 1. What about respondent number 2?
I could serve their learned advocate in the trial court. The DRT matter, what happened, we filed the memo with all papers saying matter is settled. They take 3 weeks, 6 weeks adjournment each time saying, yes, I'll consult head office before I withdraw the case. They permit me to serve it on their DRT advocate.
The petition is permitted to serve the notice on the second respondent advocate, the counsel appearing for the second respondent before the DRT.
And emergent notice can also go to the second respondent so that they know what's going on.
Issue an emergent, in addition to that, issue emergent notice to second respondent. List this matter once a notice is served.
45.
Much obliged.
I appear for the petitioner in this case, 45, my lord, serial number 45. My lord, my friend was not even issued a notice in advance. He has filed a wakalat. I have no objection. But, my lord, my petition is both the husband and wife are locked in a petition for restitution of conjugal rights. Husband has sought divorce. Wife is seeking conjugal rights. In spite of that, she files another suit apprehending that I am going to get married again, which is against the law, and even there is no cause of action against her. And my lord, order 7 rule 11 application has been rejected.
Please come to the impugned order.
Yes, my lord.
Yes.
Page 15, page 17, my lord. My lord, there should be a reasonable cause of action for her to say that I am getting married again. It is castigating and creating a defamatory statement. How can I get married? I am Hindu. My wife is yet to be divorced. I have not divorced. Court has not passed any orders. Merely on apprehension, how can my learned friend's client file such a sweeping suit? And there is no tangible cause of action to say I am getting married, either an engagement or either a settlement with any lady. With great respect, by the learned judge has not applied the mind of the scope of Order 7, Rule 11, A and D. My lord, I am a Hindu. My marriage is still intact. She files a restitutional petition which is pending.
Where is the plaint?
Plaint, my lord, kindly see page 36. My lord, so far her petition is concerned, it is at page 136, annexure K, 136.
Who
136.
filed the restitution of conjugal rights?
The wife has filed. That is at page 36, annexure C. It is her petition for restitution. I have entered appearance there. I have filed a counterclaim under 23 capital A for divorce.
1 minute.
I don't have petition, my lordship. 1 week time I required, my lordship. I will answer every question.
Then counsel for the petitioner shall show the copy of the writ petition on the counsel for the respondent. Lizzie's matter.
My lord, till then there may be an interim stay, my lord. Why? Because why should I suffer the option of the suit?
We'll have next week. Yes.
My lord, a date may be given, my lord. Please.
Speak according to the board will take up.
Well, still number 46.
Therefore, the petitioner, my lords, case wise application for interim maintenance and residence order has been rejected by the trial court on IA number 2 and 3, my lords, which has been challenged by this writ petition, and the wife is before your lordship, my lords. Impugned order is by annexure A, my lords. I'm challenging this order, my lords, on few grounds like it's not a well-reasoned order, my lords, and whatever the documents and evidence what has been produced by the parties has not been properly appreciated by the trial court, my lords. If your lordship look into impugned order by annexure A at page 23, my lords.
Who are you, wife or husband?
Wife, my lords.
How much is granted?
No, it has been rejected. The application, both the application has been rejected.
Let's read the order.
Yes, my lords.
Come
At
to the
page
order.
23, my lords. Orders on IA number 2.
Yes,
May I read it, my lords?
yes.
The respondent wife file IA number 24 under section 24 of the Hindu Marriage Act, read with section 151 of CPC seeking maintenance penalty of 75,000 per month and litigation expenses of 2 lakh from the petitioner husband, my lords. The respondent in support of her IA has shown the affidavit reiterating their stand seeking maintenance penalty and litigation expenses. In this case, the respondent has filed her objection statement to the main petition. The petitioner has also filed his objection opposing the grant of any maintenance penalty. Both the petitioner and the respondent have filed their affidavit of disclosure of assets and liabilities. May I take your lordship into the relevant portion, my lords? Para 5, my lords. At page 25. Both the petitioner and the respondent have furnished their affidavit of disclosure of assets and liabilities. The petitioner in his affidavit of disclosure of assets and liabilities has revealed that he has pursued MBA and now residing in Canada. The petitioner in his affidavit has revealed now he is unemployed and working as Uber driver there in Canada, earning $2,500 per month. The respondent in her affidavit of disclosure of assets and liabilities has revealed that she has pursued, it is MA, my lords, not MFA, MA in Bharatanatyam.
So why should this application be dismissed like this?
My lord, the contention was that the wife is unemployed per se, as she has no other income other than to rely on her husband's income in this case. But they have conveniently not disclosed the fact that the petitioner is choosing not to work. My lord, now this goes a lot behind the history.
It's
I
not that.
understand, my
It
lord.
is not, you cannot supplement anything in this order by way of your argument.
Yes, my lord.
The order should contain all that. It is not at all a well-considered order.
My lord, the order has been the trial judge has considered this order based on a lot on the oral submission as well as
It should reflect in the order. When the
It may
court
be-
reads the order,
Yes, ma'am.
court should feel that it's a well-considered order.
Yes,
It-
ma'am.
No consideration at all.
Yes, my lord.
This
In-
order needs to go.
It may be reconsidered by the trial
Yes.
court.
What about IA number 3?
IA number 3 is also filed under section 19, read with section 26 of the Protection of Women from Domestic Violence Act, my lords. Relying on the order passed on IA number 2, that is under section 24. I will take your lordship, page 27, my lords. And liabilities furnished by petitioner make out that he has pursued MBA and now he is working as Uber driver in Canada. This court, while considering IA number 2 file seeking grant of interim maintenance by the respondent, the same has been dismissed. The materials on record make out now the petitioner is residing here in
What is this
Bangalore.
residence order?
Residence order for alternate accommodation for the wife, my lords, or to pay the rent. Section 26, 19 read with the section 26 of DV Act permits, my lords.
Yes, next.
For that
What
also.
about IA number 7?
7, I am not challenging, my lord. That is application filed by the husband, my
I'll set
lord.
aside these 2 orders and remand the matter back for presence.
Yes, my lord. It may be.
Agreed with orders passed in I number 2 and I number 3 in MC number 5978 of 2023 dated 16/9/2025. The wife is before this court. The wife has filed I number 2 under section 24 of the Hindu Marriage Act seeking maintenance penalty light or at rupees 75,000 per month and litigation expenses of rupees 2 lakhs. Then the second IA, that's I number 3, is filed under section 19, read with section 26 of the Protection of Women from Domestic Violence Act, read with section 151 CPC, seeking for residence order, directing the husband to secure the accommodation for the respondent as enjoyed by her in the same household and pay rent for the same. The court had dismissed both the applications. While dismissing the application, the court had narrated the facts that are stated in the respective petitions and further observes that the petitioner and the respondent have furnished their affidavit of disclosure of assets and liabilities. The petitioner in his affidavit of disclosure of asset, instead of saying petitioner, husband in his affidavit of disclosure and disclosure of assets and liabilities has revealed that he has pursued MBA and now residing in Canada. He has revealed that he is unemployed and working as an Uber driver in Canada, earning to 2,500 pounds per month. The wife in her affidavit of disclosure of assets and liabilities has revealed that she has pursued MFA in Bharatanatyam and MSc in psychology. In her affidavit, she has revealed that now she is residing at her parental home in Bangalore. The material on record make out first that the wife had filed this petition in Kerala, and on the transfer petition filed by the
My lord, the petition was filed by husband in Kerala.
the husband has filed in Kerala, and basing on a petition filed by the wife, it has been transferred from Kerala to Bangalore. Hence, in those backdrop of the facts, the court is of the opinion that at this juncture, the wife is not entitled for maintenance, penitentiary and litigation expenses. When it comes to the residence orders also, in the light of the dismissal of I number 2, this I number 3 is also dismissed. Next parallel, and counsel appearing for the respondent. And counsel appearing for the petitioner, wife submits that the order is not a well-reasoned order. Why the court has not granted maintenance to the wife? There is no reasons in the order. It is submitted that when the wife is not in a position to support herself, it is a duty of the husband to grant maintenance to the wife, to give maintenance to the wife. It is submitted that the order is bereft of reasons and the same needs to be set aside. Next parallel, and counsel appearing for the respondent submits that though the wife is well educated, in spite of the same, she is not working. Considering the said aspect, the court had rightly dismissed the applications and there are no grounds to interfere. Next, having heard the counsels on either side, there is the material on record. There are 2 applications filed before the court, one seeking interim maintenance and the other seeking the residence order. Both the pleadings of the parties are before the court, and both the parties have filed their respective statement of assets and liabilities. While considering the court has to consider the application basing on the evidence available on record. This court has perused the order impugned. As rightly argued by the land counsel for the petitioner, the order is bereft of reasons. The court, without assigning any reasons, has just like that had dismissed the application which needs interference of this court. Hence the order impugned dated so and so in I number 2 and I number 3 is set aside, and the matter is accordingly this court is passing the following order. The order is passed by so and so in I number 2 and 3 dated so and so is set aside, and the matter is remanded back to the family court for fresh consideration. The family court shall decide the same in accordance with law by assigning due reasons within a period of 2 months from the date of receipt of the copy of the order.
Number 47.
Much obliged, my lord.
Petitioner.
Not here for the petitioner.
Yes.
No, the petitioner is a wife, not the respondent. Husband had filed a petition for divorce on the ground of cruelty. It was filed in the year 2019. For 5 years, my lord, they do not contest the case at all.
So what is the impugned now?
The impugned order is an application for amendment after the evidence of the respondent had closed, including 2 reliefs of adultery and.
Let's see. The wife is the petitioner.
Wife is a respondent in the trial court before the Honorable Family Court. The petitioner husband, my lord, would file a petition for divorce. Then, my lord, he does not lead his evidence. His evidence is discharged. Then I lead my evidence. At the stage of cross-exam, he does not cross-examine me. Then the matter is posed for final argument.
MC is of the year 2019.
Yes, my lord.
That's filed on the ground of cruelty and adultery.
Only cruelty.
Cruelty.
Then, my lord, an application is filed subsequently in the year 2.
See the order.
My lord, may kindly.
Before seeing the order, let us see the IA that affidavit that is filed.
IA for amendment, my lord, would get at page number 198, annexure J, my lord.
So by way of this amendment to add 1 and 1B after the word section,
Desertion, he would add adultery also. And my lord, the affidavit, my lord, after evidence, my lord, he says, I had inserted all this to my earlier counsel. My counsel did not do it. That is the ground.
no, this affidavit is filed on 9/10/2023 after 4 years.
Yes, after 5 years, my lord.
It's after 4 years, I think.
4 years,
2019.
yes, my lord, yes.
So what was the stage here? at
It
that-
was posted for final arguments. Because my evidence was over, the respondent,
Now
he did
please
not
come, now please come to the order. Page number?
Page number 34, my lord. What happened? He files 3 applications, but I have challenged only the application of IA number 6, my lord. Page 34. The petitioner side has filed present IA 6 under order, it's actually order 6, rule 17, read with 151 CPC, seeking amendment of petition, their petition. The petitioner husband, in support of his IA, sworn the affidavit, reiterating his stand, seeking incorporation of certain facts. The respondent has filed her objections opposing the amendment of the petition. The petitioner, the husband, has filed the main petition under 13(1)(1)(a) of the Hindu Marriage Act, seeking dissolution of the marriage by decree of divorce. The petitioner in his petition has contained several facts attributing cruelty. The
Which
petitioner,
court
the
is
present
this?
IA,
Which court is this?
family court, my lord.
Which is the court?
Place.
Bangalore. Family
No,
court.
there are so many family courts.
It is the 6th additional principal judge family court, Bangalore.
Hmm.
President IA has sought dissolution of the marriage on 2 more grounds based on adultery and also on desertion. The petitioner, the present IA, has sought incorporating facts leading to desertion and adultery. Now the case is posed of cross of RW1. However, it is necessary to give maximum opportunity to parties to defend their case.
Please come. The petitioner, wife is before this court, questioning an order that's passed in I number 6, whereby an application that is filed by the respondent husband under order 6, rule 17, CPC is allowed. The learned counsel appearing to the petitioner, wife submits that initially MC number 3459 of 2019 is filed, seeking divorce on the ground of cruelty. In the year 2023, an IA is filed seeking amendment whereby he has sought the divorce on the ground of adultery and desertion. It is submitted that after filing the divorce petition, the husband has not come forward for leading his evidence, and when the matter is posted for final arguments, at that point of time, this application is filed. Learned counsel appearing for the petitioner submits that when an application is filed at a belated stage, the court, without assigning any reasons, in a mechanical manner, has allowed this application. Next para. Having heard the learned counsel for the petitioner, peruse the order impugned. When the suit is filed in the year 2000, when the MC is filed in the year 2019 on the ground of cruelty, and now they are seeking an additional ground of adultery and adultery and desertion. When the matter is at the stage of final arguments, the order impugned does not reveal any reasons why this application is allowed at this stage, except stating that by allowing this application, no prejudice would be caused to the other side. On the face of it, it appears that the order is passed without assigning any reasons, and also contrary to the settled law. In that view of the matter, there shall be stay of all further proceedings in MC number 3459 of 2019. The petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect. List this matter after vacation.
Bill number 48, Dhananjay Kumar.
Yes.
For petitioner, my lord.
This petition is for challenging the order dated 2/8/2025.
Page
But-
number?
Page number 24, my lord. IA number 2 is dismissed by the trial court. Annexure A.
No, this is an order that is passed by the,
In MC case, my lord.
not in MC.
In MC case, filed by the respondent.
It's a criminal miscellaneous.
It is filed by the petitioner, my lord.
No. You are assigning an order under section 12 of the Domestic Violence Act filed before the JMFC.
MFC. It is filed by the petitioner. We are challenging the MC case, my lord.
Where is that? You said the order is at 25.
16, my lord. Annexure 16, sir.
What is this order? IA filed by respondent is hereby dismissed. What is this IA?
For maintenance, my lord.
Take off notice. Notice the respondent. And someone's, let's this matter in the month of January.
Cell number 49.
Let's say I appear for the wife, my lord. I had filed an anti-suit injunction before the trial court, my lord, without granting any reasoning. The trial court has issued only notice only after the 1 week, my lord. So I am before your lordship because otherwise the husband, the respondent will obtain the divorce in US court, my lord. He has sent all the email and the notice from the council, my lord. My lord, the order is in page 124, my lord. The trial court order, IA number 3, my lords, where I have asked for ex parte ad interim injunction restraining the respondent to proceed in the divorce proceedings before the American court, my lords, Manchester. The order starts from page 124. Without any reasoning, my lord, trial court has only issued notice to the respondent. My lord, the parties got married in Bangalore. My lord, the parties have the children who is studying in Bangalore, aged about 13 years. My lord, thereafter in 2017,
What is the other material?
My lord, in 2017 they had a.
No. About his prosecuting the petition abroad.
My lord, he has sent an email, page 59, my lord, annexure L. 59, annexure L, my lords. Last and final call. My lords,
Received from whom?
From the husband, my lord, to the wife. My lords, thereafter, annexure M, my lords, page 60, he has received the notice.
What did he say? Please read that.
Yes, my lord. Since divorce USA cost huge amount of money, I am giving one last try to make sense. I would prefer to have the mutual divorce in Bangalore, so and so, Kolkata, to use money to for my daughter, my lords. My lords, but I have to give little bit facts of the case, my lord.
Let's read, let's complete it.
Yes, my lords. I have changed the terms and conditions a little bit. Everyone has a right to live a life happily and free of tension. In this case, Archana's strong arm tactics are making it difficult, but I will just give one last try before this coming Saturday. I will file divorce in the US. If there is no response from Archana's side, I am trying to be very flexible, but it seems there is silent treatment, gaslighting happening based on inputs from some nasty people. So by Friday, if this document is not read and replied, I will file divorce in the US and I will not reply to any court proceedings in India. So and so, my lord. My lord, before this email, my lord, what has happened is there was an FIR filed, charge sheet was filed.
It was when?
My
This
lord,
was on 9th July 2025.
yes, my lord. My
Where
lord,
are
I
we
have to
now?
Well, let's have to show the conduct of the petitioner, that is the husband. Now he is telling about gaslighting and other things. He comes before this court. He says that we'll reunite, and he says that I'll take the child and the wife to the US, my lord. That is page 40, my lord. Before this court itself, my lord. The memorandum of settlement, my lord. Annexure H, page 40. Paragraph number 5, my lord. The respondent number 1 shall be
In the
joining.
year 2018.
Yes, my lord, this is criminal petition 2018, but it was decided in my lord, 2020.
Please understand. No,
My lord, 11/1/2023, my lords, this was decided.
this mail is in the month of June.
Yes, my lord.
Then now the court has already issued notice.
Yes, my lord. My lord,
Wait for some time.
my lord, he will obtain the
When the
divorce.
matter is going to be listed.
My lord, 6th, my lord, this,
So these kind of, the exchange of emails between the,
yes,
or you should have responded to him.
no, my
That
lord,
you please come to India, we'll mutually settle it and all. Why should you go to the court?
my lord, he has already done all the proceedings before this court only, my lord, family court, and he has quashed the entire criminal proceedings. Thereafter, he goes to America and sends this email, my lords, that because she's unable to challenge in USA, my lords. That
When
is
is
why,
that, when was this order passed? It is on 25/11. Office is to issue emergent notice to on I number 3 and sue summons to the defendant through court
yes,
and
my lord.
speed post, WhatsApp, email, returnable by 6/12.
Yes, my lords. But my lords, he obtains the order from this court.
When is 6th?
My lord,
When is 6th?
right. My lords, please, my lords, because he
This is matter. We'll see what the court is going to do. This is matter next week.
obliged.
Cell number 50.
Appear for the petitioner, my lord. My lord, the impugned order is at page number 158.
What is that?
Five IAs have been taken together. We've only challenged IA number 7. This is in a custody matter. I appear for the petitioner husband. Now, we had filed for 50% custody, and the only reason that the trial court has rejected my application under IA number 7 is because I do not regularly reside in Bangalore where the child normally
Please to
resides.
the respondent.
My lord, any interim order might be granted because there's only minimal and symbolic visitation, my lord. Any public place or in the weekends.
Only after the respondent appears.
But
enters
there are
appearance.
also 3 connected matters. I'll provide it to you.
This matter, the petition is permitted to take out hand summons on the council and shall file a memo. Once a memo is filed, list the matter along with so and so.
Yes,
Yes, ma'am.
petition cell number 51. 51 urgent, 52. Nanjunda Swami and 52.
No representation on behalf of the
My lord.
appellant. I number 1025 is filed seeking withdrawal of the amount. I number, accordingly, I number 1025 is allowed and the respondent is at liberty to withdraw the money. 53
53 notice.
notice, 54 notice.
54 notice. 55.
I'm for the appellant, my lord. There is a connected matter that is 55.1.
Admit post for final hearing, call for the TCR.
Madam.
In
My lord.
55.1, memo is filed seeking
Yes,
dispensation of notice to R4 dispensed with.
My lord, we have filed a transfer of amount memo on 23/9/2025. There is already order on 26/2025, withdrawal of 50% of amount deposited before this honorable court. Hence, it
Memo
may
is
be-
filed seeking transfer of the amount deposited before this court. The registry is directed to transfer the same to the trial court.
Cell number 56. AM and
Yes.
The amount is deposited, my lord. 50%
Then
of
counsel
the
for the
amount.
appellant submits that the amount is deposited. Admit-
Call for records, ma'am.
Admit final hearing TCR.
Cell
57.
number 57.
The respondent
Smita?
2 minutes. File the wakalat today.
Yes, admit final hearing TCR. 58.
Cell number 58.
There is no FIR and charge sheet against my vehicle, please. In spite of the 40% fixed against.
How much is, what is, it's a case of death or injury?
Please, madam.
Case of death or injury.
Yeah, death, please.
How much is granted?
12 lakh 94,000, please. 50% department. And another second one more wife is there. She is also filed state by this honorable court in that MFA.
Who filed?
Another wife. One more wife is there.
What is stayed by this court?
Please, madam.
Disbursement of amount.
No, not this one. No, state, there is no FIR against, please, madam. He has 2 wives. One wife is filed by the MFA number. It stayed in MFA number 522F8 2015, please. This is second wife, please.
That I'm not able to understand.
Please, madam.
Why the wife filed for enhancement or seeking?
No, it's compensation, please. Compensation.
So this compensation
There
is
there is
granted
no
to
there
the.
is no FIR charged against my vehicle, please. The accident took place due to negligence. They deceased himself. The FIR charged against the deceased only, not against us.
The land counsel, the appellant submits that the FIR, there is no crime is registered against the insured vehicle, and the court without any basis has fastened the liability on the insured vehicle.
60, 40%.
Considering the same, there shall be stay of all other proceedings, 50%. Already deposited.
25,000 deposit. If I will deposit
There shall
including
be stay of
50%
all
out.
further proceedings on the condition that the 50% of the amount shall be deposited within a week, within 4 weeks.
Of 40%, please, madam.
No. Yes.
No, my lord. Liability fees against the 40% against 12 lakh 90,000 out
This
of
is 40% liability.
40%, 50% of 40%. Liability fees and 40% against us. That amount comes to 12 lakh 94,000. Out of the 12 lakh, if you deposit 50% before the tribunal within 6 weeks.
The insurance company shall deposit 50% of the liability, the amount, with the 50% of the liability that is fixed on the insurance company within 4 weeks. Yes. Notice to the respondent.
Urgent 60, 59 urgent 60.
59, I'm for the petitioner, my lord.
Huh?
For 59, I'm the petitioner. The other side has taken adjournment without my.
They have said so. What is that? Look at it, 59. They said they've informed to you.
They have not informed to me, my lord. So that is why I was waiting.
Huh? Morning it is said so, that it is informed. In the mentioning time, the learned counsel for the respondent had sought time submitting that they have already informed to the learned counsel of the petitioner. When the matter is called, learned counsel for the petitioner submits that if the same is not informed to him, list this matter tomorrow. The cause list shall contain this. Yes, tomorrow.
60, A and other.
Password, my lord. Password.
No passwords today because the list is going to be completed. List next week.
Number 61.
Yes.
61.
No representation after vacation. It's already adjourned.
62.
I beg to appear for petition.
My lord, kindly pass the matter. Senior is held up in other court, my lord.
No passwords today.
My lord,
List
please,
this
my lord.
matter. What is urgency in this?
Urgency, my lord, there is a direction issued by this honorable court, your lordship's order. Second time the matter comes up before your lordship, my lord, kindly see, my lord. They are harassing, my lord, without going on with the cross-examination and the examination of chief, my lord. And now posted the matter for evidence. 2 times they filed application with cost. It was imposed and it was recalled. Then also they did not come forward to. I have the order
What is
sheet.
the impugned order?
My lord, impugned order, my lord, again ordering maintenance, my lord, contrary to the direction issued by your lordship, my lord. Therefore, my lord, I will take your lordship's attention,
Yes,
my lord,
list
page
this matter
102.
next week. List this matter next week at the request of learned counsel for the respondent. Next.
Next week, any date?
We will be basing on the work.
Your lordship already, order is already there, your lordship. Without taking note of that para 9 of the observation made by your lordship.
We'll see.
The order came to be passed.
64.
53 urgent 64. K. Ravishankar.
The petitioner's property is neither a secured asset nor a secured creditor. A possession has been taken. I given a representation last time.
Where
4
is the
times they took
respondent?
time.
Huh?
4 times they took time on the footing to file the statement of objections. Neither a secured creditor or a secured assets.
The
House is there, my lord,
learned counsel for the
and livestock
No.
also.
In WP number 15105 of 2025 is present. No representation on behalf of the respondent. And also, both you appear.
Both.
On behalf of the respondent, not in, don't take the number. In both the petitions, counsel for the petition is present. No representation for the respondent. List this matter on Monday. On that day, even if there is no representation, orders will be passed on the merits of.
Very well. I'm diploma.
Cell number 65. Cell
Yes.
number 65, MD Raghunath.
I appear for the petitioner, my lords.
Appear for the respondent.
My lords, this is a petition filed challenging the order passed by the trial court with respect to the interim custody of the child, my lords. The petitioner is the father.
1 minute.
Please, my lords.
You have an order. Respondent mother shall adhere to earlier order and give access to the father to speak with child through video calls between 5 p.m. and 7 p.m. and the entire call shall be recorded. The same shall be placed before this court. This shall go on till 5/11/2025. This is this matter on 6/11. Any violation of the orders passed by this court will be viewed seriously. What was happening?
The violation is this, my lords. If I may be permitted to produce the documents.
Take that.
If my lords may kindly peruse the screenshots, my lord. In none of the video calls have been answered. Even if it is answered by the respondent, it is only for a matter of few minutes, my lord. And it's always a set message which has already been sent to the petitioner saying that I will adhere to the order of this honorable court. And once a call has been placed, she does not answer, my lords. My lords, may kindly peruse the amount of minutes that the petitioner has been able to speak to the child. It's a matter of few minutes, my lords, 4, 5, maximum 7 minutes. There have been 40-second video calls as well, my lords. And she does not answer after that. In fact, my lords had weighed on the respondent heavily in a prior writ petition.
What do you say? What are your instructions?
Out of letter and spirit, we are complying with the orders, my lord. Even we have filed the complaints of it in the content petition, lord. May I place it on record, my lord?
What is the age of the child?
7 years, ma'am.
7 years, my lord. May I draw your lordship's attention to
What is
the
this?
tabular
What is the
column.
order of the court? How much time it is?
My lord, for 1 hour, my lord.
Hmm.
But, lord, out of letter and spirit, the mother is always trying the child to sit for entire 1 hour, my lord. But it is not the, child is not comfortable with the entire 1 hour, my lord. There is, it has become very difficult for him to engage entire 1 hour.
Where the mother stays and where the father stays?
My lord, mother is staying in Madhya Pradesh.
Hmm.
Father, apparently, I was informed that he was residing in Bombay, my lord. As of now, subject to my lordship, my friend's correction.
Why can't he have the access to the child physically when he can go
Please, my lord, very well, my lord. We are not at all coming in the way of he exercising the physical visitation when he comes to
May I
Madhya
make a
Pradesh.
humble
my lord.
submission, my lords. It's not that
Now-
the father has not tried, my lords. Whenever the father goes to Madhya Pradesh to meet the child, immediately an FIR comes to be lodged, my lord.
My lord.
Saying that the father has come unlawfully, he's been dragging the child.
No,
Let
we
it-
will
let-
pass an order now.
Let him provide that any one document, my lord, when we have refused the visitation
What
order.
we do is, now we'll pass an order. When will you go?
In the winter vacations, my
Hmm.
In fact, my lord's observation was
Please,
this,
my
my
lord, I'll
lords.
get-
On the last hearing date, my
But-
lord's oral observation was that with respect to winter vacations, there will be some kind of a settlement made between the parties where the mother would bring the child to Bangalore, either to Bangalore or somewhere in between, my lords, where the
So when
father
you're
also can
staying
go
in
and meet.
Bombay, why should the boy be brought to Bangalore?
My lords, the petitioner is residing in Bangalore, not in Bombay. It's only
My
the
lord.
petitioner's parents are residing in Bombay. The petitioner is residing in Bangalore. He's working in Bangalore, my lords. And therefore,
Let him,
No, where is she comfortable? In Bangalore or in Bangalore, Bombay?
my lord, she is residing in Madhya Pradesh. Apparently, she is a doctor, my lord. She is practicing there in Madhya Pradesh. Child is also admitted to the school in Madhya Pradesh, my lord. He's going to the
Small village, if this is the case, I
yes, my
remember.
lord.
Please,
that's a small
exactly, my
village.
lord. The other day, your lordship said that, people who are studied in the rural areas have gone up to the certain level, and even she studied in Madhya Pradesh and she has pursued her MBBS, MD and all those things which are produced. my lord. Now, apparently, my lord, whenever the father visits to Madhya Pradesh, my lord, we are giving physical visitation to him, my lord. As far as this video calls is concerned, now trial court has passed. Kindly peruse, my lord, the operative portion of the trial court order, my lord. Every Saturday, my lord. Even out of letter and spirit, we are providing video calls whenever the father, is engaging with the child, my lord. But apparently the father is making many allegations against the mother, my lord. We cannot compel the child to sit for entire 1 hour with video calls to instruct with
By
the
what
father, my
your
lord.
client is proposing for the vacation?
Winter vacation, my lord, let him file an application whenever he is, able to visit Madhya Pradesh, my lord. According to that, I'll get instruction from my
So why
client, my
don't you
lord.
come down to, so that the boy will also have a, the vacation failing by coming to.
I'll get instructions, my lord. When is the winter vacation, and we'll.
So when will, it is like this, when he can come to Madhya Pradesh, when she will come to Bangalore.
Please, madam, I'll get instructions.
Please
When,
get your convenient dates. He will get your,
Please, ma'am.
he'll come up with his convenient dates. Then
Please, madam, we can
please
do so.
exchange it to the other.
I'll do so, my lord.
Will.
At least my lords may order on that aspect. Please.
The land counsel appearing for the petitioner submits that the wife has not complied with the order passed by this court. Land counsel appearing for the respondent submits that, in fact, the wife has been complying with the order passed by this court, but the court has directed the video call for 1 hour, as the child was not comfortable for 1 hour. The entire 1 hour duration, she couldn't continue the video call. It is submitted that if the father can come to Madhya Pradesh to meet the child, mother has no objection. Considering the fact that the winter vacation is fast approaching, this court deems it appropriate to pass the following order. Both the counsel for the petitioner and respondent shall get specific instructions when the mother is intending to travel to Bangalore and when the father intends to travel to Madhya Pradesh to meet the child. List this matter on 15th of December.
Please, ma'am. In the
Very
meantime,
well, Lords. Please.
in the meantime, my lords may direct for at least the contact rights to be.
Contacts rights we are producing, my lord. The impugned order says that video calls about 30 minutes as per the convenience of the child, my lord. We are giving video calls, my lord. Now the allegation my learned friend is producing
The
is
order-
modified for 30
the
seconds, 1
earlier
second.
Order passed by this court with regard to the video call shall go on.
My lord.
Please, ma'am.
Each and every day it is become very difficult for the mother, my lord. For entire 1 hour. Again is coming and making allegations that video calls for only 10 minutes. 30 minutes.
As per the convenience and comfort of the child.
Please, my lord.
My lords, that would again become a problem, my lord. This is the whole and sole reason, my lords, that they've been coming before, my lords.
All these orders are not, to fight against one another.
I agree, my lords.
What is the purpose of granting
meet
1
the child,
hour
my lords.
when the boy is not comfortable? No, a boy of 7 years, will he be comfortable talking 1 hour through video call?
Definitely, my lords. The only problem is
May I
they've been
make one
teaching the
submission?
child to abuse the father, my lords.
My lord, may I make
They've
this
been
submission,
teaching
my
the
lord?
child.
Only persons who can interact for entire 1 hour is, my lord, friends, my lord. Second thing is lovers, my lord.
Yes.
Third thing
It's
is
not
any
my
any
lords,
person who is complaining
it's the
against
father.
another person, my lord. How can we
So
expect the
coming up
child
on
to understand?
15. Yes.
My lord, that doesn't mean they do all these aspects, my lord.
My lord.
Next.
My lords, at least let it be half an hour, my lords. It couldn't be at
20 minutes.
my lords.
My lord.
If that was the case, I would have asked for 45 minutes, my lords.
Yes.
Please, my lords. Much obliged.
6 to 6.
My lord, I am for the respondent. Paper on time, my lord. No objection happens on mean time.
In serial number 66, I appeal for the petitioner.
I am for the
My lord, there is only one short point before this honorable court. As against the claim of 69, as against the claim of
I didn't know if somebody,
69,047
the
rupees
council is
for month
appearing, please, sir,
maintenance.
to have the
Interim
papers.
maintenance. What has been awarded is only
the objection next to the hearing, my lord.
Objections are not required in this.
notice has already been served.
Please this matter next week at the request of
And
non-council.
those who are not paid even the interim arrears.
We'll see next week, 6 to 7.
Arya Devanand.
In the meantime, let them pay the arrears, you know.
Yes.
Respondent.
And I seek for a pass out for a short duration of 15-20 minutes, or it may be taken up at 2:30. It's a small matter.
Because it's already, the list is completed. So do not 2:30 matters today.
Let it be tomorrow.
Because,
Tomorrow.
yes, not tomorrow. Can I persuade my lords to have it on Tuesday?
Yes. Tuesday, DRT matters are coming, Wednesday.
10.
Yes.
Cell number 68.
As I appear for
Vishweshwaraya.
petitioner in this matter, kindly pass on, my lordship. In a council will be there.
Yes. Any urgency for you?
As agencies, I am pressing for interim prayer
What is interim prayer?
regarding visitation rights, my lord.
Let's see.
Last occasion, in fact, your lordship has heard this matter for a while
Hmm.
and asked me to, my lords, produce the documents.
What is impugned order?
That's impugned order is granting visitation rights.
Where is that order? Which page?
My lords, it is at page 16.
Page 16?
16.
I number 2 filed with
Yes,
the
ma'am.
petitioner, so and so is allowed.
Petitioner is
Permitted to pick up the child from the house of the respondent at 8 AM
on every
on
second
every
Saturday
second Saturday with him and drop the child
at
at
6
6
p.m.
PM on Sunday by keeping the child with him as overnight custody on Saturday. First 3 days interim custody during the Dasra vacation Christmas. You are for the,
Wife, ma'am.
uh,
Petitioner wife.
what is wrong with this order?
Earlier arrangement was, my lord, before the family court, every day, my lords, on every Monday and Friday was visiting the, my lords, and he had the visitation rights. And he was coming to the house of the petitioner and visiting the child. Only objection is, my lords, we have only objection for the overnight stay. The reason being, my lords, there are instances of the child, my lords, beaten by her grandmother.
What is the age of the child?
It is already 5 years. Female child, my lords, it's already 5 years. My lords, we have no objection. Let him come every day and visit the child. Let him have the visitation rights. Our objection is only, my lords, we are objecting for overnight stay. That's the reason, my lords, because the child was beaten several times by her grandmother. My lord,
List on, list this matter at the request of respondent on Wednesday.
Wednesday. Please, my lord. That's
Well,
till such time, at least interim order
Lordship,
may kindly be.
Even the
granted.
previous order which was passed for the visitation, my lordship, even they are not
That's
complying
the,
on
he
the
is
same, my lord.
visiting on
And I have-
Monday and Friday.
And I furnished the
It is still such time, my lords.
documents annexed, my lord.
Yes, Wednesday.
Much
Wednesday,
obliged.
my lords.
Wednesday.
Much.
69, Abu Bakar Shafi.
Appear for petition, 1 week wasted.
It's coming up for final hearing.
Kindly see the last order sheet, my lords.
You that?
Tomorrow, please.
Why? Why the matter that is listed today should be adjourned to tomorrow?
Senior is engaging in some other.
No representation on behalf of the respondents on the last occasion.
No, no, that actually your lordship directed them to produce the, whether they are.
No, that is on 14/11. That is on 28/8, there is no representation on behalf of the respondent and counsel for the petitioner is present. This is matter on 14/11. When the matter came up on 14/11, no further adjournments will be granted is what is the order.
Your lordships directed them to produce the affidavit that they are at least obeying the interim order.
Tomorrow.
Affidavit, they, your lordships
Yes,
directed.
this is matter tomorrow. No adjournment. I will not grant no passovers, no adjournments.
Please.
Tomorrow.
I am grateful.
Yes.
Number 70. 70, Syed Khalil Pasha.
Petitioner in this case, ma'am. Already.
Where is the respondent?
Already my side already argument is.
Huh?
My side argument already hold, my lord.
No representation on behalf of the respondent. Counsel for the petition is present. This is matter in the month of January.
And interim
Look
order.
at it, interim order is there, extended. Yes.
On passed over matter, sale number 24, passed over matter,
Yes.
Sorry, my lord.
passed over
My lord,
matter.
I had filed 13B application, my lord. before
24. What is the serial number?
24, my lord. Office has raised certain objection, my lord. Formally, I have made them party, my lord. Trial mediation center and also the.
You shouldn't.
I will delete it, my
Office
lord.
objection shall be complied with within a week.
My lord, I will delete it. I have to file in a memo.
No, whatever, the office objection shall be,
My lord, I had already made them a party. Office objection has raised that why
but
we
you have to
made-
delete that, that you file.
I'll file.
And you have to carry out the amendment also.
Yes, ma'am, that- but
Shall do
may I-
the needful within a week. Once the needful is done, list this matter.
Tuesday, ma'am. Tuesday.
Huh? Tuesday.
Obliged.
10, 12.
Done?
9, 12.
Tuesday. 9.
Sir, memos date. ಅಲ್ಲ ಅವನು ನಾನು ಮೆಮೊ ಇಲ್ಲೇ ಇದೆಯಾ ಅಂತ ಚೆಕ್ ಮಾಡಿದೆ.
ಇಲ್ಲ ಮೆಮೋಸ್ ಚೇಂಬರ್ ಹೋಗಿದೆ ಮೇಡಂ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಕಳಿಸ್ತಾರೆ 11 ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ 36 ಡಿಸ್ಮಿಸಲ್ ಆ ಟಾರ್ಗೆಟ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ
ಅಲ್ಲಿಂದ ಹೋಗುತ್ತೆ ಅವಾಗ
ಇಲ್ಲ ಅಲ್ಲಿಂದನೇ ಹೋಗಲ್ಲ ಬರುತ್ತೆ ಚೇಂಬರ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ನಮಗೆ ಕಳಿಸ್ತಾರೆ ಮಧ್ಯಾಹ್ನ
ಮಧ್ಯಾಹ್ನ ಮೇಲೆ
ಬಂದಿದ್ದು ಅನಿಸ್ತದೆ ವೆಂಕಟರೆಡ್ಡಿ ಅವರ ನಿಮ್ದು ಅರ್ಜೆಂಟ್ ಇದೆ ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸಲ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟು ಮೇಡಮ್
WP 25018 ಅಂತ ನವೆಂಬರ್ 3ನೇ ತಾರೀಕು ಆರ್ಡರ್ ಅನೌನ್ಸ್ ಮಾಡಿದ್ರು ಅದು ಇಲ್ಲಿವರೆಗೂ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ.
ಮೇಡಮ್ ಬಂದಿದ್ದಾರೆ ರಿಲೀಸ್ ಎಲ್ಲ ಮಾಡ್ತಾರೆ.
ಡೈರೆಕ್ಷನ್ಸ್ ಇತ್ತು ನವೆಂಬರ್ 30 ಪೇ ಮಾಡಬೇಕು ಅಂತ ಬ್ಯಾಂಕಿಗೆ. ಬರ್ತೀನಿ ತಗೊಳ್ಳಿ. ಅದು ಏನ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇತ್ತು ಏನಾಗಿದೆ
ಫೈನಲ್ ಆರ್ಡರ್ ತಾನೆ?
15 crores ಗಿಂತ ಜಾಸ್ತಿ ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇದೆ ನಾವು ಬ್ಯಾಂಕಿಗೆ. ನವೆಂಬರ್ 30ನೇ ತಾರೀಕು ಒಳಗಡೆ ಪೇ ಮಾಡಿ 30ನೇ ತಾರೀಕು ಒಳಗಡೆ ಪೇ ಮಾಡ್ಬೇಕು ಅಂತ ಡೈರೆಕ್ಷನ್ಸ್ ಇತ್ತು. ಹೌದು. ಸೊ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಅಂತ ಪೇನೇ ಮಾಡ್ತಿಲ್ಲ. ಅದೊಂದು ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ ಮೇಡಮ್. ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಅದೊಂದು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
59 ಸೀರಿಯಲ್ ಅನ್ವರ್ಟೋಗಿಂದ ಡೇಟ್ ಇದೆ ತಾಂಬೋಡ 59 ಸರ್ 59 ಅಲ್ಲ ನಮ್ಮ ಕೊಟ್ಟೆ 59 ಆವಾಗಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಟಿಸ್ ಅಂತ ಡೇಟ್ ಇದೆ ನನಗೆ
5.51 ನಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಮೌಂಟ್ ಸೀಕಿಂಗ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಅಮೌಂಟ್
ಇದೆ ಅದರಲ್ಲಿ ಈಗ ಎರಡು ಅಡ್ಮಿಟ್ ಮಾಡೋದು ಒಂದೇ
56 ಅದಿಂದದು ಒಂದೇ ಅಡ್ಮಿಟ್ ಮಾಡೋದು ಯಾರೋ ಒಂದು ಅಲಾಂಗ್ ವಿತ್ ಸೋನ್ಸ್
ನಂಬರ್ ಕೊಟ್ಟೆ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀನಿ
ಇದೆ ನಾವು ಮೂರಾ
ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀನಿ ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟು ಕರೆಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಮೇಡಮ್ ಕರೆಕ್ಷನ್ಸ್ ಜಾಸ್ತಿ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ನಮ್ಮ ನೋಡಿ ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಟ್ಟು ಕೊಡ್ಬಿಟ್ಟು
ಇದು
ಜಾಸ್ತಿ 13 35 ಜಾಸ್ತಿ ಇರೋದು 1364 91
ಏನಾಗಿದೆ
ಅದೇ ಬಿಫಿಲ್ ಹೆಸರು ಬಿಟ್ಟಾರೆ ಅಂತ ಅದು ತೆಗೆದು ನೋಡಿ ಸೇರಿಸಬೇಕು ಅದಕ್ಕೆ
ಬಿಫೆಗ್ ಮಿಕ್ಸ್ ಆಗಿದೆಯಾ
ಅಲ್ಲ ಬಿಫಿಲ್ ತೆಗೆದು ಎಕ್ಸ್ಟ್ರಾ ಇದೆ ಅದು
13640 ಇದು ಅದು ಮೇಲೆ ಇಟ್ಕೊಳ್ತಾರೆ
ಇಲ್ಲ ನೋಡಿ
13614 ಅದು ತೊಳಿ
ಇದು ಮಧ್ಯಾಹ್ನ ಸಿಕ್ಕಿಲ್ಲ ಎಲ್ಲ ಮುಗಿದೋಯ್ತು
ಈ ತರ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ನನಗೂ ಖುಷಿ ಆಗುತ್ತೆ ಕೆಲಸ ಮಾಡಿ. ಡೈಲಿ ಹಿಂಗೆ